On April 1st of this year, the Supreme Court ruled that a death row inmate in Missouri could be executed via lethal injection, despite the fact that this inmate suffers from a rare medical condition that would cause him extreme pain during such an execution. So the thought is for this guy, if he is executed via lethal injection, he runs the risk of choking to death on his own blood. Writing for the majority opinion, Justice Gorsuch reasoned that the Eighth Amendment does not guarantee a prisoner a painless death. And he goes on to say, as you see here, of course, that isn't guaranteed to many people who are victims of capital crimes in the first place. But the dissenters had a different view of the Eighth Amendment's cruel and unusual punishments clause, with Justice Breyer arguing that execution would be excruciating and grotesque, and Sonia Sotomayor reasoning, if a death sentence or the manner in which it is carried out violates the Constitution, then that is a stain that can never come out. So the narrow majority that decided this case, Bucklew versus Precythe, with the 4 liberal justices on the court signaling deep disagreement with the majority's interpretation of the cruel and unusual punishments clause, is a really good example of the power of dissents. So even though the dissenting view in a Supreme Court decision does not have the force of law like a majority opinion does, I want to talk tonight about the importance of dissenting, not only for the court's legitimacy, but also for the development of law in the United States, and also for its importance to whom the justices are speaking to when they dissent. In each case before the Supreme Court, justices are presented with a set of choices in generating the outcome that a court is going to reach. Somebody can choose to write the majority opinion. Justices can choose to join the majority opinion or vote in favor of it. A third wiggly room option is if you agree with the outcome, or if you agree with the way that the majority reached the outcome, you can concur with it. But then the last common choice is either to write or to join a dissenting opinion. So if you are joining or writing a dissenting opinion, you are voting or writing in a way that is in opposition to the majority. So unlike a justice who writes a concurring opinion, a justice who dissents does not agree with the outcome of the case, nor the way that the majority reaches that outcome. So dissents are actually a really recent phenomenon in judicial politics, and they also don't happen as frequently as we think they do. So this graph shows us that from 2000 to 2016, unanimous decisions were actually the most common type of judgment, representing about 36% of all decisions made by the Supreme Court. On the other hand, 5-4 decisions, or these decisions we think of as close calls or really politicized, only represent about 19% of the decisions that are made during this time period. So given this fact, the first thing I actually want to talk about is consensus. So one reason why we see so many unanimous decisions on the court is that the court really values consensus or agreement. And Chief Justice Roberts, this is a picture of him speaking at his confirmation hearings in 2005, noted that as a Chief Justice, he would have a particular obligation to achieve consensus. So he is saying, there's something really awesome about a 9-0 decision, right? We value agreement on this court. So why might the Chief Justice make it a priority to reduce the number of dissents? Well, consensus contributes to the Supreme Court's legitimacy. Strong or unanimous majorities make us think that the court is deciding in ways that represent legalism, fairness, and impartiality. And all of these are traits that the American public truly values in judicial decision-making. As such, if the court is making decisions in this way, the American public might be more likely to accept decisions, even if we don't agree with the content of those rulings. Another reason why consensus is so important is that a unified voice from the court makes the process of interpreting decisions a lot easier, not only for future Supreme Courts and lower courts, but also other implementing populations like Congress, local schools, the president, you name it. So if we believe in the value of precedent, and if we believe that there is a value to the wisdom of past decisions, it's probably a lot easier to interpret and implement those decisions if we hear them from one voice. Okay. This is all well and good. Consensus is really cool, and I'm so glad we got it out of the way. But what about when a Supreme Court justice has not only deep-seated contempt for the majority's opinion, but is also positively perplexed about how the majority could possibly, ever, in a million years, reach the decision that they did? Well, my friends, that's probably when you dissent. Okay. So Supreme Court justices are probably more likely to dissent when they disagree with the majority opinion writer's ideological position, or when a case takes on a lot of issues versus a few issues, because you can imagine if a Supreme Court case is dealing with a lot of different pieces of a puzzle, there are more places where you could potentially disagree with the majority. You're also going to see dissents more often when the dissenter does not have a history of agreeing with the majority opinion writer, even if those two people aren't ideologically distant. And these predictors of dissent are actually more prominent today than they were in courts of the past. So, in fact, since Elena Kagan's successful nomination to the court in 2010, we are actually living in the first ever era where no Democratic appointee on the Supreme Court is more conservative than any Republican appointee. And what this means is that the court is more divided on both partisan and ideological lines than we have ever seen in the past. So as a consequence, we actually shouldn't be surprised to see more consistent levels of disagreement about the interpretation of not only the Constitution, but federal and state laws. And while consensus is very important for the court's legitimacy and for easy to interpret jurisprudence, dissenting is also very important. Internally, dissents put pressure on the majority opinion writer to, in the words of Justice Ginsburg, refine and clarify the initial opinion draft. So research has found that opinions tend to be longer when they're dissenters. So I'll just put this graph up here. So if the majority opinion writer recognizes that there might be weaknesses in their argument that are uncovered by the dissenters, they're going to feel compelled to respond to those limitations, thus increasing the length of their opinion. So what you can see in this graph is that on average, over time, the length of Supreme Court majority opinions is increasing, and we see that especially as our court is becoming more polarized. Dissents may also form the foundation for future decisions, giving future majority coalitions a basis for their decisions. So a legal historian named Melvin Urofsky, he wrote a book a couple of years ago about visionary dissents and their impact on Supreme Court decision-making. So take, for example, the slaughterhouse cases. I see some 335 people out there smiling because, you know that slaughterhouse case? The majority in this case ruled that Louisiana could impose regulations on the butchery industry. So it turns out, if you were a butcher working in the late 1800s, how do you dispose of your animal carcasses? You're like rotting pieces of animals. You just throw them in the water supply. Makes a lot of sense. This is a great idea. So it was causing a lot of problems, and the Supreme Court said, yes, Louisiana, you are allowed to interfere with the butchery industry because this is causing some health problems for the public. But not to worry, Justice Stephen Field disagreed. He thought that throwing these animal carcasses into the water was a great idea, and in his dissent, he argued that the right of free labor, one of the most sacred and imprescriptible rights of man, was violated by the Louisiana law. And Urofsky argues that Field's dissent in this case motivated a whole era of Supreme Court decisions that favored individual and businesses' economic rights over state regulations. And one of the clearest examples of the power of a dissent is that of Justice Harlan's sole dissenting opinion in Plessy versus Ferguson in 1896, where the majority in this case found that separate facilities for African Americans and whites were constitutional. Harlan argued that in the view of the Constitution and in the eye of the law, there is in this country no superior class of citizens, and Harlan's dissent in this case paves the way for the decision in Brown versus Board of Education in 1954. And I could go on and on with examples of how dissents of the past have shaped decisions in the future, but dissents have gone on to shape majority decisions that have established the right to counsel in criminal cases, have established religious freedoms, as well as the right to marital and consensual sexual privacy. But finally, justices write dissents for you. Believe it or not, they write dissents for you. So not only are dissents valuable for the internal politics of the court and for future decision making, justices are also thinking about their legacies and their audiences when they're writing dissents. And Scalia, here's Scalia and Ginsburg riding on an elephant. This is one of my favorite photos of all time. Scalia was particularly vocal about this purpose of dissents. And in a 2013 New Yorker interview, he said that he writes dissents with students in mind because they will read dissents that are breezy and have some thrust to them. That is who I write for. So to sum up, yes, a plurality of Supreme Court decisions are ones of consensus, but you should keep an eye on dissents like Breyer and Sotomayor's in Bucklew v. Precythe, as not only do they likely influence the content of today's majority opinions, but in the words of Ruth Bader Ginsburg, they also speak to a future age. She said, the greatest dissents do become court opinions, and gradually over time, their views become the dominant view. So that's the dissenter's hope, that they're not writing for today, but they're writing for tomorrow. Thank you.